Hello, my name is John Mayer, and I'm the Executive Director of CALI, the Center for Computer Assisted Legal Instruction. The video you are about to watch is from the annual CALI conference held at the University of Michigan School of Law in Ann Arbor, Michigan on June 4th and 5th, 2026. Most U.S. law schools are members of CALI. CALI publishes over 1,400 interactive tutorials that teach the law to law students. Faculty can also use LessonLink to create formative assessments using CALI lessons. CALI publishes casebooks by paying law faculty to write and review books that can be adopted in many courses in law school. These books are free to download from our website, or print versions can be purchased at near cost. You can download the PDFs or even the Microsoft Word versions of most of our books and add your own commentary before distributing to your students. $300 casebooks are a thing of the past, and adopting one book from CALI saves you more than your entire institutional membership. If you would like to learn more, email me at jmayer@cali.org. I would be happy to visit or zoom into your school to talk about CALI.
Okay, hi. All right, recording in progress. Hopefully people can hear me. For posterity's sake, because people in this room know who I am, I'm Debbie Ginsberg. I am the Manager of Emerging Technology Initiatives at Harvard Law. Yes, I made up that title. Maybe I'll make up another title. So now I deal with AI and some other things. Come on in, sit down. This is not just going to be about law libraries and 512, opinion 512 from the ABA. I'm going to sort of expand it. And I'd like it to be a little conversational. Otherwise, it's going to be a fairly short presentation because I'm still sort of thinking about these things and looking for help. And the fact that apparently this is going to be recorded and maybe I can download it and get some, a transcript I could put through AI. Maybe I could do something with this. All right. Hi, you want to go forward? Cool. So who here knows what opinion 512 is before I have to explain it? Cool. A lot of people. What? You have to ask it? Okay. Yeah. All right. So it's a formal opinion from the ABA, American Bar Association, put out in July 2024 that walked lawyers and others who are interested through the different rules of professional conduct. I'm going to assume people know what the rules of professional conduct are. Anyone don't? That's fine. I can explain. Okay, cool. We all know that. We've heard it a zillion times this week already, or the last 2 days. It feels like a week. And explains like how they come into play when AI is concerned. So, well then. So it walks through competence, confidentiality, supervision, candor, fees, communication, all of these, and probably more, are implicated through the use of AI. And the ABA wanted you to know all about it. So what I did recently is I did a article for the Spectrum where I was like, this is what some of these rules mean for law librarians. Now, of course, many of us law librarians aren't acting in our lawyer capacity necessarily when we are law librarians. So they'd be like, well, does this really affect me? But there are aspects that really do, particularly in terms of if you're academic, what we want to teach our students. So I'm going to be focusing on that aspect here because this is an academic conference. So we've all done the rule of competency. We know what it is, competent representation to a client. And of course, the maintain requisite knowledge and skill, keeping about technology to know what the risks and benefits are. So we've gone through this particular rule many, many times, particularly the 40 states that have adopted some version of Common 8. So what the 512 has to say is to competently use a tool, you don't have to become experts. And this is what we've told lawyers again and again. We're not supposed to be experts in technology. You're just supposed to understand the risks and benefits, the limitations. And here, of course, don't rely on the tool's output because that could violate the duty of competence of Model Rule 1.1. And all this seems pretty straightforward, right? We're told again and again, can't rely on it. We have to understand it. We have to understand whether it's putting out good information or not. Which then brings me to one of my first questions. What does competency mean? What does it mean in a situation where I've rarely seen as force? Anyone seen an opinion where like the lawyer violated the duty of competency as opposed to some of the other ones? And I think it's kind of rare because it's not an off-on situation, right? There's a lot of judgment call. Yep. Wait. I got to put you on last. Go.
Place I've heard it implicated is in the maintenance of client trust accounts and the use of deep fakes, et cetera, to try to get money out of client trust
That's
accounts.
interesting. Okay. I would have done candor for that, but that's it. Anyone else have an answer for competency? We're going to come back to competency later, so think about it. We got 1.6 confidentiality. You know, you're supposed to keep your client's materials safe. The ABA says there's a lot of uncertainty involving how the AIs use your information. Are they protected? What happens to the input and the output? Is something going to be disclosed to others inside or outside the firm? And I'm sure some of you have seen instances where some lawyers like, I'm using ChatGPT Pro for my clients. Did you at least click the box so it's not used for training? Did you read the terms of service? Are you also using Google, which really doesn't want you to turn it off at all? This is one that scares me, and of course, ones that we like to talk to our students about a lot, because this is one place to start to introduce students to the concept of you are responsible for your tools. So, question there, what is reasonable? And the reason I'm asking this is right now it's kind of obvious what's reasonable and what's not reasonable, right? There are AI companies that are getting your information, using it for training. There's others that are keeping it secure. It's all in terms of service. It's all pretty obvious. Though I've come across instances where at one point I was sure that Notebook LM Pro was not being, my stuff in Notebook LM wasn't being used for training. And then I had to skip like through 80,000 documents to figure out that it in fact was. So A, it's not always clear. B, if you all remember, who here was around for the advent of email? And if you remember, there was a lot of controversy then. There was controversy when we went from print to electronic research as to what was being protected, was it safe? And now, of course, we all think it's safe today. Are we going to reach a time that, well, you know, the stuff's used for training, but it's not going to be regurgitated wholesale. It's going to be anonymized. That's probably going to be good enough. Is it going to be normal enough so that this is going to be as much of a worry as email? Though then again, there is Gmail. What's the problem with Gmail? In many cases, it continues to scrape your information for advertisements. And yet, lawyers use it all the time. Still a problem. So, anyone see confidentiality being less of a concern? Does anyone respond to that? Cool.
I just wanted to point out that there's a New York opinion stating that as long as the bots are the only ones looking at it and not humans, Gmail is fine because it's not actually being viewed by a human. It's when the human crosses the line that it's an issue.
Okay. All right. But who here knows of those current opinions that have come out for attorney-client confidentiality where we had one where in a criminal case, the defendant had used, I believe criminal, a Claude, I guess some version of Claude to come up with some kind of legal strategy and insisted that this was part of the attorney-client strategy conversation and was dinged for it and was told it was not confidential. And there's another case, good job, where there was a pro se who was working on their materials through a GPT. And because the pro se, everything pro se does inherently is protected by the occurring client relationship, it was fine. So, Jenny, again, cool.
So the New York opinion was an email opinion from the 90s, but you're talking Hepner and I think it's Warner is the other one.
Yes.
So we are seeing those, and I think it's important to tell people it's just like an online diary. It's not protected, but now there's your real diary. So
right. So there's that aspect of it. That was my question too, as to wait, why would it be protected?
Because everybody thinks it's like their lawyer. I don't really understand the thought process that it should be, to be honest. But that's just me.
Okay.
There is a opinion in Ohio though when you come back to vendors that I want to talk about.
Okay. Pass it on.
I agree with the idea that just because a computer touches it, that shouldn't be having studied intelligence cases that are public, in addition to being an intelligence operation. Anything that a machine can access, if it's saved, will eventually come into the eyes or potentially come in the eyes of a human, regardless of how many regulations there are on humans, because humans are human and will search the database. And also at any point in time, they can be like requested, or there can be some sort of like, oh, the FBI asked for it, and then no one's going to check to make sure it's privileged before like they give it up to somebody because they don't care. And so don't ever assume what they say is the limit, because there's always 1,000 million exceptions, and there's also tons of access with the humans. So it's just nicer to assume, if you don't have full control of where it is and who's seeing it, someone you don't want to can see it.
So you're telling me that if I upload my Lexus contract into Bloomberg, even though they say it's encrypted, I shouldn't trust that?
Okay. So you can see, at least if nothing else, there's plenty of lessons that we can take just from this one rule to talk to our students from. There's what the law says, there's how it is interpreted in some strange ways, and then there's the reality of the situation. If it's not protected because it's accessible, someone's going to access it whether you like it or not. So we'll see what happens. All right, then we have the duty of supervision. And who here is a lawyer? Got some lawyers here, and if we have the duty, if we had a firm, we would have the duty to supervise people working for us within our organization. And even if you're not a lawyer, as a lawyer, the non-lawyers who are working for me, I also have to supervise as well and make sure that they are keeping up with what they need to understand for using AI, which is what the Rule 512 or Opinion 512 says. You have to establish clear policies. Supervisory lawyers must ensure non-lawyers comply. Includes training staff on the use and risks of using AI. Cool. In the article I talked about, probably firm librarians will be involved with this for here in academia. Again, this might be something we want to talk to our students about, because when they become lawyers, they're going to be working with other people and they have to understand how far their obligations go. Which then, of course, obviates how far do those go. We've got the problem, of course, people using shadow AI. You don't know what is going on. And you think you have trained everybody, and you think that they are following your policies, but they aren't necessarily, and that can lead to problems. The other thing, and I'm going to see if people have thoughts about this. I can't remember which, I think it was a state opinion I was reading that kept comparing the information from the AI itself as needing supervision akin to the Rule 5.1, 5.3. And they kept saying it's not like a person, but it's akin to a person. I'm a little bit disturbed by that. Does anyone think that these rules should in some way apply to AI outputs per se? Maybe? How about not? Any thoughts about this one? Yeah. Should just bring Jenny to the front row.
Is it actually shadow AI if the attorneys tell you that they're using it?
I'm thinking of the people that, are like, oh, yeah, I'm just going to get my personal chat GPT and just run it really quick. No one's going to know, or I'm not even thinking about it, which is half the time it's going through.
But I know a lot of attorneys who are using AI and they go tell their librarians, even though it's not firm vetted. The librarians are like, what did you do?
Yeah, so they're not even supervising themselves at this point. And when they're not supervising themselves, what on earth are we going to do? So again, all these information from the ABA is really useful, but then it gets to the real world and we're not sure what's going on. Those were the three that I talked about in my article because I thought they had the most implications for law librarians per se, and I only had so many words to write. But I've also, of course, been thinking about all the other ones that are referred to in the ABA opinion. About the duty of candor, you can't lie to the court. Great. You have to, use actual authority. You have to disclose it, whether it's good for your side or not. And here it says, of course, issues have arisen because of hallucinations, bad interpretations, misleading arguments. And for a while I'm thinking, oh yeah, the duty of candor is going to be around forever. But what people are saying, though I need to see the data actually believe this, we're seeing fewer hallucinations, fewer things that are just made up out of whole cloth, maybe. And maybe as AI gets better, it can finally understand how a case is put together. Anyone see cases where like the AI thinks the dissent is the actual opinion? Case A quotes case B, and the AI's like, case A says whatever case B said. I've had cases where it could not understand 19th century legalese. But let's say those problems are solved in the future and the AI becomes actually reliable. What will be accurate enough? Where does the line pass where we're not as worried about the duty of candor, where we think we can trust the AI? Or are we so far from it we can't even imagine it yet? Who thinks that day is going to come? Who thinks that the AI is never going to be this? Who thinks that the LLMs are not actually AI and we're waiting for the real AI to show up that actually can do intelligent things and work like a network? Right, okay. So one of the things we've been waiting for. And again, right now, this is where I see a lot of the hallucination issues come down, is you're in violation of the duty of candor. And that's an easy one. I'm just waiting for the day where it might get more difficult. I don't know. Any questions about that one? Statements? Yes. All right, I'm going to give this to Nick, and Nick, if you pass back. Wait, Nick was going to answer it, but then, okay, go ahead.
Okay, so I think to avoid bringing philosophy too deep, it's a problem of the heap, right? So it's hard to tell exactly when that point will come, but we'll know when it comes, right? It's the idea that like a grain of sand isn't a mountain, but eventually we have mountains and nobody can really tell you the difference between a mountain and a hill. There's a hill, there's a mountain, and so it'll definitely come at some point where we just trust it. I think the best sort of analog is with e-discovery, right? It took a long time for us to feel like what exactly that process was and how much we trusted it and how much it was helpful, but they figured it out. I think that's going to happen with this. I think the bigger problem is how we're going to continue to incentivize sort of the good best practice workflows around it when the clients still have misconceptions about how much it can be done with it. And so they're expecting you to perform at a level that you can't with it if you're following best practices. And so at what point does the incentive become shortcuts because you're having pressure from the person paying you in some fashion because they don't really understand that it's not supposed to cut this much time off, just this much time. And yes, it's helpful. Yes, I will use it, but it's not going on its own or that kind of thing. I think there's a funny Alberta Tech one where she talks about tokens and the CEO is just like, use more tokens, use more. Then he gets the bill and he's like, why is there a $700,000 bill for tokens? Because they cost money. It's like, oh.
What's your salary? 1,000, 150,000 per year. How much do the tokens cost? 700,000. But keep using them. Yeah, for the motivation agent.
It depends.
Oh, we have a lawyer here.
Thank you. There's currently no liability for the AI being wrong until there's a market incentive to change the current. It's not going to change. And lawyers, we have an ethical duty. LLM does not. I don't know what we make of that, but that's just the landscape currently.
Does Lexis or Westlaw have any ethical duty to be correct? Bloomberg? So, yeah, where is the money? Is the money here? Until it is. In market duty. Reputational incentives. All right, 1.5. Fees, which comes up a lot. You have to charge reasonable fees. You can't, overcharge. If your contract says you're going to charge, you need to follow your contract. And the ABA, again, is really on this, it depends, because it was sort of the opinion ranged very widely about how fees would be charged. One of the interesting things I like here is because now if we talk about this with students, we can talk about students about the business of law. It always amazed me and has amazed me over the years on how often we do not talk about law as a business. That I was like, I'd go to the students in some of my classes in Chicago, Kent. I'm like, and see if you guys can find the answer. Why are you in law school? Yeah, okay. Why are you really in law school? to make money. You want a job. The job is a business. And for many of you, you're going to be doing the business yourself. I mean, you know, I was in government or in legal aid. That's different. But if you're in a firm, you're in a solo, you're in an organization that has to support itself, at some point, you're going to have to worry about money. So what does the ABA have to say about money here? So let's say I have a job that manually takes me 10 hours, but I can do it in 4 hours with the AI. Can I charge for 10 hours of work? Raise your hand if yes. You think so? What? You did the 4 hours. If I am billing by the hour? No, why not? That's my hourly rate, which it says here. Nick wants to add to that.
I'm not an attorney.
I'm not your attorney.
Yes. Yes, you can. You're billing 4 hours for the research or drafting or whatever, but strategizing other things, if you can't find a way to spend your time on it and think of a better way to craft it by doing opposition or doing better analysis on.
Just using the extra time to do something else.
Yes, it's still billable, but you can't do it for that exactly.
Right. Kenton.
All right, I disagree with that because I think 512 speaks to this really well.
They do.
If you are trying to quote unquote pad your bills for the same work product that you used to do.
Not trying to do.
Right. It's like, so, I mean, I had this in my practice where we had a senior partner who was like, dude, when you're driving to a deposition, make sure you bill for that time that you're thinking about the deposition as you're driving. Because, you know, I mean, lawyers have always figured out how to creatively bill their clients if they're billing by the hour. And so 512 made it very clear that if you are getting the gains and you're billing by the hour, like you cannot take advantage of those gains to do quote unquote other things to fill in that 6 hour gap, right? Because the work product's the same.
Well, if he's saying he's going to improve the work product.
No, yeah, if you prove it, but you're not billing for 4 hours, you're billing for 10 hours.
Right.
But if it's like, I can do the same exact thing in 10 hours or 4 hours, that used to take me 10 hours. Can I bill for 10 hours? The answer is no.
Right.
Can I make the same amount of money is a different question.
Right.
But if you are what's that? Yeah, flat fees, subscription-based fees, et cetera, sliding scale fees. There's a lot of ways to do this with value-based pricing. And anyway, so that's why clarifying questions are helpful on, am I actually still billing by the hour or not?
That's a good question. So yeah, here they're billing by the hour. So, you know, and what did the 512 have to say about it? Just what you said, or you might want to consider other ways of structuring your bill. Are you having them pay for your expertise? Are you charging by the specific thing that's being done? There's also things about like, if you are learning how to use AI on your own, you can't charge for that. But if your client tells you you have to learn a particular AI system, you can charge for that. Which then, of course, gets us to the discussion we were having right now. What should the clients be paying for? Are they paying for your time or your expertise? Because in that 4 hours, to get it down to 4 hours, I actually had to be fairly good at using the AI. I had to ask the right questions. I had to do the right procedure. I had to learn the skill to make it happen. Similar to the skills that I would have needed to do the 10 hours for doing it by manual. So as we use AI, are we going to be consider working more towards expertise or more towards time? And that's going to be a good question. I'm going to come back to this one. Communication. You know, as a lawyer, it is my job to communicate with the client and, you know, what's going on with their case and, you know, different ways I'm approaching the case and my reasoning. I've got to tell them a bunch of stuff that. The question then comes, as a lawyer, do I have to tell them if I am using AI or not? And people, you know, the idea right now seems to be if you're using it for something like grammar, then you don't have to tell them. But if you're using it for coming up with your strategy, you do have to tell them. I'm not clear about legal research. And here, I don't know, I find that a little strange because I don't know if the line between Grammarly and strategy is as clear as people think. Because at some point, as I've been intimating before, AI is going to become normal. And people are going to assume that you're using AI to do the work in some way or another and don't expect to be told. And I'm also not, you know, right now the clients will react in different ways because we are now like, you know, there's some clients who said, you must use AI to save me time and billing. Other people like, you cannot use AI for legal research because it always hallucinates and we don't want you doing that. Again, clients don't always know a lot, so that's part of the problem. So where is this duty of communication, and what issues do you think it can cause if you're required to communicate even some aspects of AI to the clients? Thoughts about that one? What's the fee agreement?
No, if you're having to communicate use of AI, I want someone to define for me what they mean by AI. That's
There's
all.
that.
Because a lot of these discussions about LLM or systems or thing, I mean, I can imagine a system that would use AI to do citation checks, use the AI to check your sites, not make up your sites. So I mean, like the use cases, I really don't like the yeah.
Clapping, yay. Okay,
All right, that's my.
all right. And then Jenny.
There's actually a pre-generative AI case out of, I think it's Ontario,
Really?
where
Yeah, I know what you're talking about.
a lawyer lost all of his research fees because he did not conduct it per the judge with artificial intelligence research tools. I think they're referring to LII Canada, but he used the old-fashioned way and he lost his entire research fee because he wasn't using modern tools. So we've already seen it. It's just it was pre-generative AI. So to David's point, you need to define what AI is because we already have it on the case book or on the books that you have to use AI.
Yeah.
And Lexis integrated it in something like 1997, so you can't not use AI.
Right, and now they're integrating Gen AI into everything too, so you can't not use Gen AI with Lexis either.
I mean, if it's about disclosing or so two different conversations. One's
Right.
about disclosure to your client, and one's about disclosure to your client. One's about communication to your client. And if it's disclosure to your client, you put in the fee agreement that we will use generative AI for our practice on your behalf to create value for you. If the rule is communicate every time you use generative AI, similar to what the courts have said over the past 3 years of disclose, have a little certification, all that stupid stuff. Sorry, I just gave my judgment on that. So, but it is like, I don't think that's what the rule is contemplating. I think it's more about disclosure to the client. Unlike blue book rules or other rules that say, you gotta, because then it's like, what are we communicating? Are we communicating every prompt to our client? I mean, it's just like, it gets ridiculous.
Right.
And I don't think that's what the rules envision. I think it's more about disclosure, put in the fee agreement. They know and that's what the rules are all about. It's like, does the client agree that you're going to do this? Like, well, you do that at the fee agreement stage. You don't do that as the litigation keeps going or the matter keeps going.
I've seen opinions beyond this, which were all fairly unclear as to that division. So I think, having that level of clarity, where are we? Is this part of the original agreement, or is this a step-by-step disclosure? I've lost the little thing. So again, lots of stuff here to talk to our students about. And of course, the idea that this is hitting real life. And I've got a couple of brand new examples. So brand new, some court in Florida has decided that you must verify your citations and sign that you have verified all your citations. And this applies to all litigators, pro se or lawyer. And there can be sanctions if they do something inconsistent. So I'm seeing that over and over and over again, not just here. I think the Ninth Circuit just did something like that 2 days ago, and we've seen it from other circuits as well. Then there are the changes in California. Anyone familiar with these? So California is amending many of its rules to include aspects of AI. So competence, AI is relevant to technology, communicate, inform clients about cost, scope, or decisions. Confidentiality is involved. We've got issues with supervision, candor, and non-lawyer help. All these things we've been talking about, California plans to, or is going to integrate, I think that's actually passed by now, into its rules of professional conduct. So there's some debate on whether, is it necessary to amend these rules, or do the rules as is already cover what needs to be done? And of course, part of the problem is everything changes so quickly, when do the rules become out of date? I've been sitting here talking about this opinion 512. It is 2 years old by now. And so there's some things that don't necessarily make sense because we're 2 years down the line. And if California passes rules like that today, what's going to happen in 2 years? Are they going to make sense? So is it worth changing it, or should we change it on a regular basis? What should we do with these rules in light of technologies like Gen AI that we've got now, and maybe quantum computing and other different kinds of changes that could happen later? I'm going to do Jennifer, and then I'll do Kenton.
So I think we've actually already dealt with these issues. It's just people aren't willing to look at what's gone before. I think the rules cover it, but like I'm looking at a 2017 Ohio opinion that is quoting looks like a Washington opinion from 2012 that says, in addition, when purchasing internet, email, communication, and cloud-based services, a lawyer must undertake reasonable efforts to ensure that the services are provided in a manner compatible with the lawyer's professional obligations. This requires the lawyer to diligently investigate the measures undertaken by the vendor to ensure its operations are compatible with the lawyer's professional obligations, specifically determine that the vendor understands and agrees to maintain and securely store data consistent with the lawyer's duty of confidentiality.
What, 2017? But did Ohio have Common 8 passed at that time?
I don't remember, but I do know this applies to all vendors. And that means OpenAI, Anthropic, they're already covered. And we are already seeing attorneys just flaunt their obligations. But it's quoting another state, which means this is not the only state.
Obviously.
So I'll go back to the 2012 proposal for comment 8 that they said this rule has always existed where you're just saying it. So I mean, for these states like California and certain states, and I hate calling them out, but it is a little bit of like intellectual like laziness or ethical laziness to say we have to name the something every time to put it in the rule to make it applicable to the rule. And that's not why we have rules. Like no one says you have to follow the speed limit. Okay, well, the speed limit changes based on context of where you are. We're not going to say the speed limit in the rule every time. Like, it's like that's the heightened level of ridiculousness of legislation sometimes. And so it is one of those things where like the duty of candor, like Rule 11 sanctions, when you sign a document in federal court, the rules already say you are verifying to the court that everything is supported by fact or law or a reasonable argument for the extension of their which, right? So it's like, why do we need new rule? And this is what judges have been saying for a few years. There's arguments on both sides. We need to have disclosure requirements. Other judges like we already have the rule. Like, and so I think the existing rules already cover AI, especially when Common 8 says relevant technology. It didn't define what technology was. And Jenny and some of us have been talking about this for ad nauseum for years on just like, what is that definition? Do we need to define it? Is it loose enough that we can cover things like AI, or do we need to go define the thing that we're going to apply the rule to every time?
Right. And that was my thing of like, as things change, what are we going to do? So, Jenny has a great point of, one more.
I was just going to say, after the Matta versus Avianca case, Judge Brantley Starr.
Bring it up.
Judge Brantley Starr in the Northern District of Texas was the first one to issue the standing order. And I talked to him shortly thereafter. He was at SMU, actually. And I was talking about whether it was necessary, because then it became an onslaught. Everybody was doing their own certification standing orders. And he said he was hoping that his would become unnecessary. The point was only to educate attorneys, because he realized attorneys didn't understand how AI was working. So if he put in the standing order, it would force them to look at the AI that they were using. And that was the purpose behind it. Not to add on to Rule 11 or anything like that, but just to educate attorneys to look at what they're actually submitting to the court.
It's a wild way to educate lawyers. And yet. So yeah, so I keep coming back to Jenny's thing about what the vendor said, like when we started doing a lot more with cloud computing, and that was a whole new thing that the attorneys had to wrap their head around, and that was difficult enough because is it safe? Is it not safe? Is it the best option? Is it not the best option? And now we've added something even more complex on top of that. So, the order educating, I can see where it's coming from. But also, this is just the start, I think, of a lot of changes coming And I'm going to be interested to see how those changes are reflected within professional responsibility going forward. So, got a couple of things I'm also thinking about these days. We talk a lot about doing compensating, doing candor, and doing a lot of verification and keeping the human in the loop. So, was anyone at ABA Tech Show other than me here? I think it was just me. Were you at ABA Tech Show? Yeah, so here we are at ABA Tech Show. I'm wandering around to the different vendors, and they're like, I will use AI to track your billable hours, and I will use AI to do this, that, and the other. And I'm like, but AI makes mistakes. So, what are you doing to make sure that this is okay? And like, oh, we're going to keep the human in the loop. But we're using all these agentic AIs. And here we've talked about this conference about agentic AIs, where you have one AI that's training another AI, that's talking to another AI, that's talking to another set of skills. And it's just like AIs all down the line. And it becomes very difficult to track where an AI might have messed up, what might have messed up. The data may be so far structured. The end result may be so sort of differently structured from your original data that it's hard to tell what's changed and what's wrong. Where do the rules of professional responsibility lie when you almost cannot be the human in the loop? And I'm not sure what happens then. And I don't know if you have any thoughts about this, because I'm struggling with this one. Okay.
So I think the first part about keeping a human in the loop is difficult one to answer, but I think if you design the systems with your people in a way that like you're not just adopting what they're selling from vendors, which is like 90% of what you shouldn't do anyway, right? And then I think it's possible, right? I think there's serious concerns about agents, and any reasonable CIO will tell you not to pull the trigger on creating an entire law firm of agents at this stage. It's like jumping on the shadiest roller coaster of a rotating fair. You're like, I don't know how many screws are loose yet. Let somebody else write it for a week, and I might jump on it then. But I think the bigger question I have that I think we jump over as we train students about this is like pushing back against people wanting to jump on all of them, because one of the biggest problems with adopting tech is data integrity over time. And as the systems change, as this vendor just showed up and may die in a week, a month, a year, because the market is currently flooded and they're going to pare down, we don't know to whom. How interoperable are these systems you build? How reliable is it when it shifts? Are they going to change the model out from under you so that you are now getting different responses than the ones that you personally actively trained for? Do you have that written in your contract? It's just that ability for it to be something in a year and a half. We talk about how fast it's changing. It's really concerning when it's every vendor just using an API through, and you have no idea which one will be here. And that data integrity is a really big question.
Right. Also considering that for many law firms, the initial underlying data is problems to begin with. We've been talking about student data and the fact that often that doesn't get cleaned up. And of course, they're part of your professional responsibility is you're supposed to clean up your client data. So now you got ancient client data getting into your AIs. And David was going to add to this as well, and then I'll get to Kenton.
I always, in keeping the human in the loop, I always get really anxious about the notion of moral crumple zones. Right, the idea of like having a human in the loop just so they can be the one we blame when something goes wrong. And so, yeah, I don't remember who phrased that. It was someone much more clever. It might be a Cory Doctorow thing or something. I don't know. But so moral crumple zones I look out for. But then whenever I think about human in the loop, I also think about 3 Mile Island.
Oh my God.
And if the report that went in afterwards to find out what the causation of the problem was, there's this temptation in safety science. Well, safety science actually has gotten very good about this. There's this temptation people have to blame operator error for things. And safety science has sort of realized, oh, it's system design, as Cass was saying. And so if in this question of like educating people, educating attorneys by this, like there's obviously something when I see all of the cases where people are submitting briefs with citations, there are a lot of people who are just like, why don't they get it? And I'm like, well, there's obviously something wrong with the system design, because if it keeps happening, I guarantee you none of these people, well, not none of these people, but these people do not set out and say, I'm going to not do right by my client. So system design and crumple zones, I'd watch out for those.
Yeah, it happens again and again. Where does the blame lie? Kenton?
So on to crumple zones. So I think about with any kind of emerging technology, it will mature, and then we will just accept the tolerances of risk over time, right? Like I think about airline traffic, and I fly a lot, and I hate flying. And it's a massive system. It's not just the plane, it's the air traffic, it's everybody, right? And we still see accidents happen, crashes happen. I'm not going to call them accidents because a lot of them are preventable. But we've accepted the risk and the tolerances, and we've created a liability framework because we know that air traffic actually helps our economy, right? Stuff like that. So the benefits are there. And so I think with this, in the legal side, it's similar to TAR, so technology assisted review and e-discovery. Early days, a lot of people are like, this is ridiculous. We would not give e-discovery over to the machine. And today we accept the tolerance, but we also have samples that we can test to see. And so, and yes, there are errors, but we accept those as the risk. And so I think there will come a time as we mature this that it's the nature of the market just to absorb that risk and accept it and then point the blame when blame's needed. But we're at that moment right now where it's still the inflection point of like, oh my gosh, what is going on? And so I think we will get to that point, but with every other system, we have learned how to tolerate risk. I'll never forget. What's that? Well, I remember I flew from Las Vegas to Nashville, and they held up the plane for 20 minutes because there was a crack in the fan blade, and they said it, and I was like, "Let me off this plane," and they're like, "It's within tolerance," and I was like, "There's zero tolerance, right?" And they're like, "No, there's engineering tolerances that we accept," and I was like, "No, there are no tolerances," but no, there's still tolerances. Yeah, so.
Right. And I think one of the other things that comes in here that I don't think we brought up yet is the fact that, of course, humans make, we brought it up obliquely, humans make mistakes too. And at what point is AI more reliable than us? And we see that with the idea of self-driving cars, which may be the next AI technology to be normalized, where, people say, I've got data that proves that the self-driving cars are more efficient and better than humans. The other thing that we've talked about a little bit is the death of the billable hour. And we talked about, are we going to start typing, which is never dying or is going to die now? I don't know. But, it's one of the things that people keep talking about that, if we're going to charge, if AI comes in, then maybe, and it's making everybody so much more efficient, maybe we're not talking about billable hours anymore. Maybe we're talking about discrete products, discrete actions that we take and we charge for those. Does anyone have like a minute of stuff to say about that? Okay, I'm going to have Cass, but then I'm going to move on.
I deeply hope it breaks the billable hour, largely because as it takes all of the sort of lower level, like menial, tedious tasks that we do, that we need our brain systematically to do to get to higher level tasks, our brains need kind of like classic Einstein worked at the patent office, right? Dead brain to make your brain do bright things. We're going to have a lot more trouble figuring out how to actually do enough work to bill if every single piece of work is all of that absurdly high level thinking work, because nobody can do that for 35 billable hours.
Okay. Yeah. And that, of course, also the problem comes in, that's how we train the new lawyers, right? So already I'm hearing people say, maybe we don't need so many new associates in our firm because it's all going to be replaced with AI. And then I'm like, oh my God, we're not there yet. So, and back to then, what is competency really? And what does it mean to be competent in AI or competent in just being a lawyer in a place where everything is changing all the time? And this is another thing that I'm trying to struggle with. I know Kent wants to talk. Okay. Kent, you and I should have just teamed up for this one with Jenny and Cass and David and all that. But that's why I opened this up for a reason.
Everybody in the room. So when I think about, I've been thinking about competency for over a decade. And I think this question is something we hoped to answer a few years ago. And we realized how not insurmountable, but how amorphous the idea is. And so, there's different ways to look at competency, obviously, like levels of competency. And, but if I'm thinking about lawyers, what I really want them to be is just, and this is hard. I mean, this is where like Cat Moon would say something like this on like, hey, can we just get people to be curious and just have a curiosity competency? But then to Cass's point, like we're so busy and tired. And like, if you talk to a lawyer that is a solo mid-sized firm practitioner, it's like, how you doing? First thing, I'm tired, you know? It's like, so they don't have any room for innovation or competency, like development. They don't have, and so we need judges to pass orders to hopefully train lawyers, because that's the way we're going to do it, with a stick instead of a carrot. And so it's just, what is competency really? I mean, obviously it's in context to where you're at and how you serve your client, provide value to your client, and the means to do that. But how do we measure it? I have no idea.
Right. And that's, I think, why I don't see that as much. Jen?
I agree with Kenton. It's a moving target. I think it's one where we need to come to some sort of an agreement, but I would start with fluency at this point, more so than competency. Just knowing how things work, I think, would better help us. But it's a scale that I don't know that we can. It's kind of like, I know it when I see it,
Yeah.
but I really don't like that, because how do I know it when I see it with 187 1Ls?
Right. Or I'm trying to talk to them about, like, be curious about the tools, understand how the tools work. And they just want to know, how do I read this statute and what do the key numbers say? And I don't blame them. Yeah, that too. But that's not I'm embedded, so I just go in and do the basic stuff. All right. So this is, of course, just the start of the conversation of ethics that we're having with our students, is within the purview of the rules of professional competency. But I'm seeing, as we talk about AI, a lot more is implicated in the discussions that I'm having with students in the class. Personal ethics comes in, the role the lawyers have in society. What does it mean where so many people are using AI as a lawyer, some more competently than others, as it were? We see issues that the AI is going to do too much for us, and then we've got cognitive issues, and I think we've addressed that to some extent, of like, if we don't get to do those base things that help our brain wrap up to the more difficult things, what are we going to do about that? And those are some of the big questions that we're sort of asking when we think about ethics and other issues coming with this particular technology and anything that follows it. So, one of the things I'm thinking about when I'm doing this is, if we've got particular examples in class, I can tie them back into the rules with interpretations that they are now, but the idea of stressing that these interpretations keep changing. But then, during these discussions, I find that the students then want to go back to the ethics. So who here is finding, when you talk to students in class about AI, they want to talk about the environmental issues. They want to talk about the financial issues, all the other things. All right, so are you raising your hand because you agree, or you got something to say? Yeah, okay, agree. Okay, yeah, this is what I'm seeing. The students are excited to talk about. They're engaged. They want to have these conversations because this is something that they can see affecting them in the ways I just showed you on that previous slide, their jobs and other things as well. And what they find, they're really getting what's personal to them. Now, and I love this because as a librarian, this is one of the first times I get to talk about these ethical issues in this broad way in the classroom, because I've had issues with Lexis and Westlaw for a long time, but I'm like, well, Westlaw does blah, 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 and Lexis does blah, 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 and that's going to be too far afield for them to really grasp it, not part of what I'm teaching them. But here it's come to where they can be part of this discussion, and they're excited to be part of this discussion. Dave, you want to add to that?
Bringing it back, just something that dinged for me now that, and I'd really be curious to hear how other people think about this, because it just sort of occurred to me, like we were talking about competency, and then we go back to ethics, and then I just keep thinking about like the ethical rules as sort of like a deontological approach versus like a virtue ethics approach to like competency. Feels more like we're going to be competent, like that's, and I don't know, how do other people like address that, those two different filters? I was just curious, and I'd love
I'm
to.
not sure if I quite understand it. You got to.
So the idea like that ethics is based upon either following rules, and sort of that's the, sort of like, or is it like, an attribute of character? And I mean, that's a very traditional, like oh yes.
Apparently this is.
So
Yeah.
Debbie, thank you so much for bringing us all together to have this conversation.
That's what it's for.
I agree. CaliCon Conference 2027. So I think it's a little bit of both, but the problem with this, so my children, 8 and 5 years old, they're in a classical education model. And all we're trying to do in that education model is build virtue. That's the ethical framework. It's like, how do we be people of integrity? And so, because that cuts across a lot of different rule sets, right? And so, but I think in law school, we are not assuming, or we hope to assume, people already have that type of ethical framework, and then we apply rules on top of them and say, follow the rules. And so in law school, the ethical framework is all about following the rules. But what I'm find over the past, I don't know, 3, 4, 10 years of teaching, most students do not have that virtue foundation for that. And so they're willing to go to what they said, like, what's the rubric? Like, how do I make the grade? How do I get the credential? Because their ethical viewpoint is just follow the rules and you're excellent. And that's how you're competent, instead of like more like the more amorphous, I am a man of substance or a woman of substance. You're like, what does that even mean? You know, and it's like, so I think, I would love to see more educational frameworks around virtue building, because I think that's what a profession needs than just following rules.
How do you
Exactly. That's the problem. The incentives are not there for it in law school. And so I've been talking to a lot of people in K through 16 of how do we do this more before they get to law school, so they have that foundation for that big rule set issue.
Right. Did you want to add?
I would just ask if in virtue ethics, I mean, are virtues anything other than rules that we're imposing on ourselves? I mean, they're socially constructed in the same way.
No, I disagree.
Okay. And that takes us a little far afield from this, but gets us to the discussion that is now I'm seeing more happen in our classrooms, and I think it's going to be interesting going forward. Which then brings us to the skills that I think that the students are going to need, and maybe not surprising, because what we've been talking about what does competency mean, what is it, and we've got this idea of fluidity, curiosity, because if nothing else, we're going to teach the students to work through change. Think about the students who just graduated in 2026. When did they start? What didn't exist in September 2023? What didn't exist in September 2023? ChatGPT. And you're right. Sorry, 2022. Sorry, ChatGPT smarter. You're right. I'm losing my train of dates. It's been a long few years. But so it was only nascent in 2023. They're just getting started with it. It's less than a year old, and now they've graduated, and several years later, and now we're getting people where ChatGPT has been with them through their entire, or at least a very good part of their undergraduate education. So they're already thinking about these changes that are taking place all the time that then, has impacted law significantly in certain parts of law. Other parts of law, maybe less. It depends on who you are, where you're practicing, what you're doing. And what we're working with is trying to figure out how to teach students to work through things that are changing all the time. Which gets me to some of the things I think are our role, and I'm sure a bunch of you have an idea of what your role should be going forward, and we've got about 5 minutes for this. Part of it, of course, is informational, but I'm coming here as the law librarian, the sage on the stage, and I'm like, what kind of source do we use first when we do our research? Secondary sources. Telling that to a bunch of students who I just taught that 5 days ago in another context, and having them look at me blankly was a thing. As we try to give them the information on how to use these things. But we're also, again, trying to teach them a little bit of skepticism, because I always want the students to be thinking about what is the tool you're using, why did you choose it, what do you need to know about it to be effective at it, who owns the tool, what is their interest, where do all these things come from as we start to, become professionals. We are responsible as professionals, just like a surgeon is, we're responsible for our tools. Lawyers have tools as well. And as a librarian, I think that's part of my big job, is to teach them about the tools and how to make good selections. And if there's anyone who's in IT here as well, that's part of their job as well, because IT professionals are always looking at contracts, looking at value, looking at how things are integrated within a greater network. Because, I can just decide, I'm just going to get Claude and put it on my computer, and I've messed up all kinds of integrations that are already there without talking to IT, and then they're very unhappy. So that's sort of what I'm thinking, but I'm sure some of you have ideas as well. I'm going to start with, has anyone not raised their hand that would like to be part of this part of the conversation and say, what is going to be your actual role with the students going forward? You can volunteer, people. Who are you volunteering? Okay. What? Oh, we're volunteering Brian. Okay.
Anything I say wouldn't be understood already by this group. So of course, obviously we are informed, we're here, we know what we're doing. We want to make sure our students are on board and understand all this. So, I mean, this is a great discussion. Thank you, Debbie, for bringing us forth on this. I knew this rule was out, but we haven't talked about it in my law school. So I don't know anyone else has talked about this. This is amazing that we're actually having this discussion. I'm going to share this with my faculty as much as my students. So, being skeptical is important. I see that up there and I think it's true. And I think this is an ever-changing thing because as we just discussed, AI is not a static thing, it's dynamic. And as much as it's become very ubiquitous, I like that people mentioned it's already been with our products and our vendors for years. So I don't think this is a new thing. Jenny, the case you brought up in 2017, I brought that up in a class I remember about 5 years ago. So about the cloud and all that. So anyway, thanks for having this and bringing me on board. But you guys, you know the answer to this. Make sure we just share everything we know and be the founts of information that we are.
And as librarians, we love to do that, right? Any other final thoughts? I think I can have one more person speak. Jenny.
I'm just going to say one thing I hope everyone will do is hold the vendors accountable. We're looking at you, Kenton.
We're going to start with Cleo. Okay. All right. So it went actually exactly as I hoped, where we would have this great discussion going forward and ideas to have continuous discussions about not just what these rules are, but how they affect us both in a professional and other ethical ways. I see these rules as just sort of a framework to start this discussion. So thank you for proving me correct. And we'll continue to reflect on, I think all of us will continue to reflect on what the rules mean now, what it's going to mean, what it meant before, what it's going to mean later, and what impact it's going to have on our students in the profession in the coming years. Thank you very much for your participation, and we'll be back next year.